Yo, it's JP. I'm going to talk today about settlement mills. Okay, folks, in this area of law, which I'm going to broadly call discrimination. So we're talking about discrimination, retaliation, sexual harassment, even sexual assault cases. In this area of law, there are many lawyers and law firms that do not actually file lawsuits and litigate cases. All right? And this is particularly true in the South and in the state of Florida. So these lawyers are willing to represent plaintiffs or clients in these types of cases in the EEOC process or in pre-suit negotiations, but they're not willing to actually file a lawsuit in court and litigate the case. Why? Why is that? Well, there are two very obvious reasons. The first reason is that federal courts throughout much of the South, and especially in the state of Florida, have been misapplying the relevant law for the past 20 or 30 years, okay? These cases, in any case that's in federal court, Rule 56, Federal Rule of Civil Procedure 56, governs summary judgment. Summary judgment is the stage of a case where the court can look at all the facts in the record, and if there are no material facts in dispute and it's clear that one side is entitled to judgment in the case, the court can grant summary judgment. But what's happened in the employment discrimination context is that lots of federal courts throughout the South, and especially in Florida, have not been applying Rule 56 correctly. Instead, these courts basically look at the case and say, well, I believe the defendant, so summary judgment is granted. Or I think the plaintiff's a liar, summary judgment is granted. Or, well, I like the reason they gave for terminating this person's employment, summary judgment is granted. Or, well, I don't think the plaintiff has proven their case, summary judgment is granted. The plaintiff is not required to prove anything at the summary judgment stage. The plaintiff is simply required to put forward enough facts and evidence such that a jury could reasonably conclude that, for instance, there was unlawful discrimination, okay? So suffice to say, federal courts have botched this for the past 20, 30 plus years. The 11th Circuit Court of Appeals, which governs the federal courts in Florida, has issued a number of decisions over the past few years basically saying exactly that, saying like, look, you're not applying Rule 56 correctly. You have to start applying Rule 56 in discrimination cases the same way that it applies in all of these other cases. But until that trickles down, and until the federal courts in Florida and more broadly throughout the South start applying Rule 56 correctly, there are a lot of lawyers who simply don't want to pursue these types of cases. They'll negotiate a settlement. They'll represent you in the EEOC process. They'll go to a free EEOC mediation. And in most instances, if the case resolves, it's going to resolve for a very small dollar amount because the defendant knows that the plaintiff's lawyer, is not going to file a lawsuit and go to court. All right? So that is the first reason, because of the standard, because of summary judgment being applied incorrectly, and because it being so likely that they're going to lose these cases. That's the first reason why they won't take these cases beyond pre-suit negotiations. The second reason is that even if they get past summary judgment, even if they prevail in the case, the federal courts, ever since 2010, a Supreme Court decision called Purdue, the federal courts are extremely aggressive at suppressing the hourly rates that civil rights lawyers can get in these types of cases. And in my opinion, that's by design, right? The entire system, the American legal system, is, in my view, an arm of the power structure. The power structure in America is basically dominated by corporate America, insurance companies, big moneyed interests, right? And big moneyed interests want to make it difficult for poor people, working people, old people, black people, women, whatever, right? They want to make it difficult for people to pursue discrimination cases, retaliation cases, etc. They want to make it difficult for working people and for regular folks to pursue these types of claims against the power structure. And so it stands to reason that the entire system would set about suppressing the hourly rates that civil rights lawyers can make when they pursue these types of cases. And as a result, even if they win, the juice is frequently not worth the squeeze. And so as a result of that, you have a whole bunch of lawyers in Florida who only do these cases pre-suit or through the EEOC process. Because of that, the company on the other side, the corporate defendant, the defense lawyer, they know that the case is worth a fraction of what it will be worth in court. They know there is no risk of the plaintiff filing a lawsuit, going to court, and causing them to spend the time and money in litigation. And let's talk about that, right? Because that is a valid consideration, okay? On the defendant's side, all right, if they're looking at this case and there's a lawyer involved who's going to file a lawsuit, take the case to court, litigate the case aggressively, they have to factor that in, okay? They have to size that up and say, all right, we're going to spend X, Y, Z to pay our own lawyers to litigate this case. And then not only do we have our own lawyers' fees and litigation costs, then we have the risk that the plaintiff gets past summary judgment, possibly gets to go to trial, and now we have serious exposure, okay? So the entire evaluation, analysis, or pricing of the case or the claims is completely different. It's black and white. It's apples to oranges, okay? Between pre-suit, where you have a lawyer who's not actually going to file the case, not actually going to litigate the case, versus a lawyer who's going to file the case and litigate the case. So one of the first things you have to do is you have to find out whether or not your lawyer is willing to file a lawsuit, go to court, litigate the case. All right? And that's not to say that some cases can't be settled pre-suit for legitimate money or for fair value. We settle plenty of cases pre-suit. But we settle cases pre-suit where we get what we think is a reasonable value for the case. There have been many instances where we have gotten a case in the pre-suit process, but where the client has gotten a right to sue letter or negotiations are broken down, and the plaintiff's current lawyer or recently former lawyer was not willing to go to court. And that's how we wound up taking over the case, right? So you have a plaintiff, and they've been either in the EEOC process or in that process of negotiating, right, with the other side, and say there's a $10,000 settlement offer on the table, and negotiations fall through, and the plaintiff's lawyer is not willing to pursue the case in court. And so the plaintiff's lawyer exits the case, and the plaintiff's looking for a lawyer, and they call our law firm, and we evaluate, and we're like, wow, this is a real case. There have been plenty of instances where there was some kind of lowball offer like that, whether it's $10,000 or $15,000, $20,000. There have been many instances where I've seen that sort of offer, and then we get involved in the case, we file a lawsuit, we litigate the case, and we wind up recovering several times that dollar amount, okay? Why? Well, the case was worth more all along. It's just that in the pre-suit process, in the EEOC process, when the plaintiff had a lawyer who wasn't going to go to court, there was no leverage there. There was no risk of going to court, litigation costs, attorney's fees, and ultimately possible exposure at trial for a big compensatory damages or punitive damages award. So one of the biggest things that you can do to help yourself in pursuit of your case is you need to make sure that you have a lawyer who is willing to litigate the case if it's a strong enough case to go to court and go to litigation, you know? So if you're with a lawyer who's only willing to settle your case pre-suit and you're not getting what is a fair or reasonable value for the case, then you need to move on and you need to find a lawyer who's willing to file a lawsuit and litigate the case on your behalf. Jonathan Pollard, happy Saturday.